is Vitek versus Ward, and each side will have up to 15 minutes to present their arguments, but the appellant may reserve up to 5 minutes if you so choose. And I would just remind everybody not to mention the names of minors, since we're being recorded and broadcast. Are you ready to proceed?
Yes, Your Honor.
All right. You may have up to 5 minutes for rebuttal. Do you want to save any time for rebuttal?
Yes, Your Honor, I'd like to save those 5 minutes.
Okay. You can proceed. Thank you.
All right. Thank you, Your Honors. May it please the court. I'm Danielle Kulik, and I represent Staff Sergeant Brian Ward in this appeal. This is the appeal of the denial of Staff Sergeant Brian Ward's motion to set aside the default divorce decree put on his case. First, I'd like to go through a little bit of the history of the case. The parties were married May 3rd, 2014, separated September 4th, 2016. Ms. Vitek filed for divorce July 18th, 2018. And Mr. Ward's counsel entered an appearance 2 months later. There was no proof of service on him, but his counsel waived service. And just 1 month later, his counsel withdrew. At various points during this case, Mr. Ward proceeded pro se. And in just 6 months later, the court had noted on April 11th, 2019, that Staff Sergeant Brian Ward had not been served properly yet. So there was a hearing set for May 16th, 2019, and Staff Sergeant Brian Ward was served a copy of the notice and motion to show cause on May 14th, 2019, just 2 days prior. On May 15th, 1 day prior, he entered a motion to appear by phone, which hasn't been ruled on. The hearing held on May 16th turned out to be his final divorce hearing and not just the show cause hearing. So that's kind of the history and background of what we have going on here. There were just 4 main issues I kind of wanted to touch with today, even though my brief is a little bit longer. One of the first issues is that Mr. Ward obviously did not have due process notice and an opportunity to be heard. So Civil Rule 4 states that you're supposed to serve by certified mail, and if that is refused, failure upon service, then you're to issue it by ordinary U.S. mail. In this case, Mr. Ward was served continuously or tried to be served continuously by certified mail. It never went out U.S. ordinary mail pursuant to Civil Rule 4. In that case, Staff Sergeant Brian Ward needed to be home to actually sign for the pleadings when they arrived. That did not occur until 2 days prior to the show cause hearing, which turned out to be his divorce hearing. So had Ms. Vitek's counsel followed the rules and served him by ordinary mail, that would have been the proper way of service, and it may have arrived at his home sooner than it had in this case, giving him only 2 days to go to an out-of-state hearing and prepare for said hearing. In 1940, the federal government passed 50 U.S. Code 3931, which is that Service Members Civil Service Act, which is here to protect military service members from default judgments. In this case, I believe that Mr. Ward was given a default judgment in this case without being protected at all by the civil rules of procedure or the federal rules in regards to military service members. Further, when he asked for a reasonable accommodation to appear by phone, that wasn't ruled on. As we know, in this date of COVID, appearing by phone or Zoom as we're doing today is reasonable. Now, this did occur 1 year prior to COVID, so there wasn't regularly Zoom or telephone conferences, but it wasn't unheard of in 2019 to hold a telephone conference. The record in this case is silent as to what occurred the day of the hearing, whether they called Staff Sergeant Brian Ward, whether they waited any time before beginning the hearing. It's completely silent. As we know, most courts will say, hey, the hearing starts at 11, it's 11:30, Staff Sergeant Brian Ward did not appear, we tried calling him. The record's completely silent here, so we don't think any reasonable accommodation was given to Staff Sergeant Brian Ward. It's reasonable to rule on his motion to appear by phone or Zoom. It's reasonable to allow a military man serving out of state to appear and be heard. It was inequitable for the court to decide his case without him. And that brings me to my last point I wanted to touch on, which was the sufficiency of the evidence. As I touched on when we started, these parties were married and separated within 2 years. They were separated at least another 2 years prior to filing for divorce. Ms. Vitek did not get support from Staff Sergeant Brian Ward the whole time. There was a temporary order for $2,800 a month for the 7 months the divorce was ongoing. He didn't pay any of that, and she didn't need any of that. The appellee brief states that Ms. Vitek received an education, which Staff Sergeant Brian Ward was ordered to pay half of, and that she was in line to make a substantial income. Her income was not in the record as well as to what her new job was going to make. Now, with her making a substantial income, not needing his support for 3 years, the court still ordered an additional 2 years of spousal support for Staff Sergeant Brian Ward to pay his wife that he was only married to essentially before separating 1 year and 8 months. If we don't consider the date of separation, we're talking they were married 4 years. So he's paying 2 years plus 7 months of back support during the divorce for essentially a 4-year marriage. I believe this is excessive.
Excuse me, counsel.
If you look at the
Counsel,
fact, yes.
I don't know if you can hear me or not. Okay.
Yes.
Regarding your argument on spousal support, when again was the final divorce decree entered?
The decree was entered, let me see. It would have been in June of 19. I don't know if I have the date directly in front of me. Let's see. One second.
That's okay. That's okay. That's close enough. I don't need the exact date. Thank you.
Yeah.
Couldn't or shouldn't any argument or disagreement about spousal support have been appealed at that time? I guess what I'm saying is, aren't you beyond the appeal time on the spousal support issue?
Your Honor, I don't believe I'm beyond the appeal time because they did put in a timely motion for 60B relief, noting that he hadn't been served, and there's no proof of service that he received the decree in June of 19. And so when he filed his 60B saying, hey, I didn't know about the hearing, I didn't know about this decree, and he even noted his dates of military service.
Okay, then let me back this up for you a minute regarding the haven't been served, because either I'm not understanding this or there's a couple different issues being conflated here. And I just want to make sure I sort this out. In terms of having been served, he also filed a divorce complaint, correct?
Yes.
Let me rephrase that and make it simpler. You're not arguing that the court had subject matter jurisdiction over this case. Is that fair enough?
That's fair.
And it seems, I recall reading something in your brief that you're not arguing personal jurisdiction either, because he filed his own divorce that the court, I think, just took as a counterclaim. So are you having any dispute with the court's personal jurisdiction over him?
No, just due process and the amount of reasonable time given notice of a hearing.
Okay, so with regard to that reasonable notice, I'm following you then.
Thanks.
Are you telling me, because I was not able to access everything because of the nature of this case, is there no order by the court that was put online that said that divorce hearing would be on May 16th? Whether or not you got it, I'm just asking, did the court generate one?
Yes, the court did generate an order because there was a prior divorce hearing set that my client asked for a continuance of March of, I want to say 2018 maybe. And he asked for a continuance and they granted his continuance and they made that new date. And that was put online. But then there's no notice of service, proof of service. And we know in this case, he has not been getting service.
Thank you.
Thank you. So to continue with what I was saying, with a 60B motion, what we're looking for is if he filed it in reasonable time, which the court herein said he didn't, he had filed his motion just within 5 months of the divorce decree being entered against him. So I believe that was within reasonable time. And whether he had a claim under 60B that actually was fruitful. Herein, I believe his due process claim would have been fruitful, and I believe the court should have allowed the 60B to go through. Again, like I said, he's a service member. He wasn't given any protections under the Service Members Act. Counsel did not follow the Ohio Rules of Civil Procedure number 4 and just kept serving him by certified mail. The docket is silent as to the date he was given the new hearing date, and he was served just 2 days prior to the show cause hearing, which he asked to appear by phone, which would have been reasonable. And in Ohio, as we all know, we've heard this quoted many times, we're all looking to adjudicate the matters based on the merits, if at all possible. And I believe this court should overturn the default divorce decree entered against Staff Sergeant Brian Ward in the interest of justice and equity, because I believe a 60B motion, although it wasn't as long as my appellate brief, and I would have made his 60B a little bit longer, I believe it touched on all the same points that I have touched on today. It talked about due process, it talked about the notice, it talked about the sufficiency of the evidence. And I believe that the court should have granted that. And I believe it was an abuse of discretion for them to deny it. So I'm here today to ask you to give Staff Sergeant Brian Ward his opportunity to be heard in his own divorce and to overturn this default against him. Thank you, Your Honors.
I have one more question, if I could. Regarding the original trial date, you said that that was actually continued, correct?
The first date was continued. This was the continued date.
Who asked for that continuance?
My client, Staff Sergeant Brian Ward.
Did he show up for the trial?
No, so he had filed a motion to continue and that was just granted. He has never shown up in person for this case.
But in the granting of the motion, when it was granted, was the new date put in there?
Yes, the new date was put in the granting.
I guess, all right. I guess what I'm trying to say is if he didn't get it or was not aware of it, wouldn't he have shown up for the original trial date?
I believe he had gotten notice of the original trial date, which is how he filed his continuance. But again, the record is silent as to if his attorney told him, if Ms. Vitek told him. You know, it doesn't say how he was told of the first hearing, but we do know today that he wasn't given notice of the second hearing.
Okay, thank you.
Thank you.
Just quickly, you indicated a 5-month delay in the filing of the 60B motion, and I seem to recall reading in the briefs, opposing counsel indicated a 17-month delay. Can you help me with that discrepancy?
All right, let me just double check my notes here because I had it in my briefs and I just made a small outline for today. So hold on one second. So according to how my list goes, the degree of divorce was June 10th, 2019. And then the motion for relief was November 28th, 2020. So June. So yeah, it was a little over a year, but okay, I see where I said this. So he entered his appearance on June 16th, 2020. So it's 5 months. I'm sorry, I misspoke. It was 5 months after Staff Sergeant Brian Ward hired counsel and entered an appearance on the case. March 5th, 2020, a capias was issued against Staff Sergeant Brian Ward. Again, he wasn't getting service of any of these items. So it wasn't until June 16th that we absolutely know he knew about the divorce decree.
All right, thank you.
Thank you.
All right, thank you. And we're ready for you to proceed for the appellee.
Thank you, Your Honors. May it please the court's attorney, Chris Opperle, here represent Ms. Megan Vitek as the appellee in this case today. All due respect to Staff Sergeant Brian Ward, I will tell you, having spent a lot of time reviewing all the documents in this case, it's the first time that it's been brought up today in court, anywhere, in any documents, that he's actually Staff Sergeant Brian Ward. So I'm a little confused because now there's been some argument about the military service members and the federal law. None of that's brought up anywhere in any motions, in any brief, anywhere. So that's a little surprising to me. But that being said, the big argument, I think, is the due process argument that counsel has brought up today. That argument has to be made within a year. That's the whole 60B argument, which when she starts talking about that our office continuously filed a request to have him served by certified mail, those are contempts. If you take a look, she's talking about contempts that need to be served to him. The court never ever dealt with the contempt and the divorce issue. So constantly saying that he needs to be served he needed to be served properly by our office. It doesn't matter. This court didn't rule on the contempt ever did it rule on the contempt. Didn't even go into it. Fact of the matter was, this case was filed by my client. Mr. Ward also filed a divorce. The court entered a judgment entry consolidating the cases into this one, thereby saying perfecting service. When he had an attorney in his first attorney, he accepted service on his behalf. That puts him on notice of this divorce case. That's the only thing this court needs to worry about, service. The rest of it is notice of hearing. Now, when we talk about notice of hearing, it's the address that the court has on file for Mr. Ward. He had ample opportunity to indicate to the court if he had a separate address. In fact, when he filed his motions, his personal motions, he signed it with a different address, but never let the court know, and the clerk of courts know, hey, I have a new address. But you can take a look at his motions to continue and his motions to quash. All of those have a new address to it. Now, he files a motion to continue the trial. It's granted by the court, but somehow what counsel is asking you to do is to allow him to bury his head in the sand from the time that motion's granted in, that was March 28th of 2019. So from March 28th of 2019, all the way until he files his 60B motion a year and a half later, November 28th of 20, Mr. Ward's allowed to bury his head in the sand and not call someone and say, hey, where's my trial date? What happened to my trial? There should have been a trial at some point. But because he says in his briefs through counsel, I never received notice. I never received a judgment entry divorce. I never received anything. And then I just sat back and did nothing for a year and a half.
Counsel, can I ask you a question?
Yes,
Do you agree with opposing counsel, if I understood her correctly, that the court's order granting that first continuance of the first trial, that order contained the new trial date?
Yes, according to what the docket, and I don't have it in front of me, but I have the document in front of me. On March 28th of 2019, it was granted and did have the new date of May 16th on it. Yes, Your Honor.
Thank you.
So the big issue with the due process, along with there's 7 assignments of error, 6 of them needed to be filed with a 60B motion inside of a year. It was not. So assignments of error 1 through 5 and number 7 all are dealt with the fact that it wasn't filed timely. The 60B motion that was filed November 28th of 20 was not filed timely. It was 5 months after, and the court rightfully denied and basically said, so first of all, you don't have a meritorious defense in this particular matter. Second of all, you're out of time. You missed the time frame in which to do this. And so you go to the final argument that is made, which is number 6, the court erred not voiding the judgment ab initio. That you would have that if Mr. Ward was never ever served this divorce. Like he had no idea that a divorce was even filed ever, because maybe my client had filed it and served it at the place of residence and she accepted residence. That you would say, yeah, he never knew. You would void ab initio this case. Not this. He knew about the divorce. He knew about it. He knew that a trial was coming up. He knew the continuance was granted and then didn't do anything for 18 months. That is not a due process error. That's a mistake on Mr. Ward's error that he's just trying to say, listen, I was never served, so you got to give me a chance to go back to trial. Now, I want to touch real briefly on the second argument, calculation of support. There was a big argument in the original brief that made an argument that somehow the court imputed him to $249,000. It's not the case. There's nowhere in the judgment entry that says that. Nowhere. What it says, if you take a look at it, it takes a look at all the evidence. Well, what is the evidence? The evidence is, so first of all, there was a W-2 that was introduced that had his information of how much he made, which was about $98,000. There was a information from an affidavit that he filed. He filed an affidavit in 2020 stating he made $98,000, and the previous year he made $95,000. So the court had the evidence before it, and Mr. Vitek didn't show up to trial, and now wants to say that all that evidence is not proper, and somehow the divorce, the length of marriage, which was date of marriage, date of divorce, somehow should have been shortened to somewhere between 2 to 4 years. That's an argument for him to make to the court. There's no argument, not even a filing. You're not going to find a filing anywhere that says there's a de facto termination date of marriage. That's not even filed within here. There's that argument, all of that just fails. I apologize. I don't know how much time I have.
You still have about 7 minutes.
All right. Again, I guess the big thing that I want, I'd like this court, that you're going to hear, I know that you're probably going to hear from counsel again, talking about the service issue. He wasn't served with the notice. It doesn't have to be served with the notice. It just has to be provided notice of the hearing date. It's not service. There was a contempt that was filed by our office, and it was perfected by service 2 days before trial. But that doesn't mean that notice of the hearing wasn't sent out earlier, and he should have been placed on notice because this case was going on the entire time. So whether he was served with a contempt 2 days prior to trial, he had notice it was sent out. It's in the docket. There's docket notations that talk about hearing notices going out. And so he could be right. Maybe he never was served notice. Maybe there's a problem of failure of the mail. We don't have that information, but there's a process that the courts rely on in terms of how someone gets notice. And for someone to sit back and say, yeah, I knew this case was continued March 28th of 2019, but I didn't call or look into it until November of 2020. That's not someone that's showing that they are staying up on their divorce case, knowing that a trial date had been set and moved. So there's argument from, I'm sorry. There's argument from, I apologize. There's argument about ineffective assistance of counsel. I don't know where the ineffective assistance of counsel would come in, because the discussion talks about the temporary support order. Well, there's no failure of the temporary support order when he files an affidavit shortly thereafter, in which the court uses income lower than what he says his income is when he files his affidavit in January of 2019. Court, it argues about the court not ruling on a motion to appear by video. He filed that the day before. And again, counsel, I think in either the brief or reply brief, kind of seemed to intimate that, how do we know that he knew there was a trial date the next day? He didn't allude to it, but he files this motion to appear by telephone the day before trial and wants everyone to believe that he didn't know about the trial date the next day. He wasn't aware. He hadn't received notice. The court hadn't done what it's supposed to do. Not the clerk of courts hasn't done what it's supposed to do. Not the plaintiff. Plaintiff doesn't have to provide notice, has to provide service of the contempt. Again, I would ask this court not to be confused between the contempt and notice of the trial dates. The error denying the 60B motions, in the appellant's brief indicates that there's two meritorious defenses: lack of due process and ineffective assistance of counsels. Those are just really a restatement of what we had talked about. Both of those fail, on top of the fact that had to be filed within a 1-year time frame. This is a 60B, and the argument is that it's the court made a mistake, was inadvertent or neglect or fraud by not serving Mr. Ward. It's not serving, again, it would be giving him notice. Somehow the court was mistaken or inadvertent in not giving notice of the new trial date. That's okay if you want to take that argument, but that still has to be filed within a 1-year time frame. And it was not. It was filed a full 5 months out. Now, I will say this. Today is the first day, and I mean no disrespect if it's truly Staff Sergeant Brian Vitek. If it is, today is the first day I've even heard that term, Staff Sergeant Brian Vitek. If you take a look in the brief, it's nowhere there. There's nothing that has been ever filed or relayed to our office from prior counsel that he's actually in the military and actually deployed and actually had papers. There's nowhere in the record on that. If he is Staff Sergeant Brian Vitek, I apologize for my statement in there that he's not in the military. I just would have expected that someone in the military providing us that information. It's vital. If he's deployed and he's somewhere, he needs to provide that information to the court. Well, we don't have any of that. That's never been. And in fact, if you take a look at his motions, give an example, his request that he filed a request on May 15th, a couple different requests. When he signs those requests, he doesn't sign those as military personnel. Your Honors, I'd like you to take all this information that you have here today and realize the big thing is that the 60B motion was denied because it was untimely. All these arguments follow because they should be 60B arguments. The void ab initio argument, that fails because Mr. Ward knew about this case to begin with. Because he started his own divorce case, which was put into this divorce case. Thank you, Your Honors.
Thank you. Thank you for your presentation. You do have only 3 minutes remaining because there were some questions at the last minute. But I'm going to just ask you, because I wanted to ask you during your first argument, and I didn't. What is in the record about his military status?
And that's where I was going to address this. It's in my brief. The motion for relief states Mr. Ward was deployed abroad from August 31st, 2018 until March 25th, 2019 as part of the Army Research Lab. That's motion for relief, page 2. It is on the record there. Further, in the transcripts, Ms. Vitek herself testified. She was asked point blank, is he in the military? And she said, yes, the United States Air Force. It's in the record in the transcripts. Thank you. May I continue with my reply?
Yes, just except one thing. I'm just confused. But there was never any mention what his actual role was in the military or the position that he held.
There was no statement of his rank. Actually, I was just doing that today because I'm trying to address him the proper way. If you would like, I can address him as Mr. Ward. But yeah, I'm just using his
No,
proper
because
name.
whatever's in the record is what's in the record. We can't go by anything else. Okay, thank you.
Thank you. So you pretty much answered what I was going to. This is not the first time his military service is brought up. It is both in the motion for relief and in the transcripts. Ms. Vitek testified, yes, he is in the Air Force. As to the 60B and the 1 year, it is well documented and in my brief that what constitutes reasonable time for a 60B motion depends upon the facts of each case. There is no hard, fast 1 year or you're done deadline. My case continued. Appellate courts found a request for relief untimely where the movement failed to explain the lapse in time. Herein, we have explained the lapse in time. We've explained he is in the military. We have explained that he was representing himself and he was abroad. We have explained these things in the 60B and we have explained them in our briefs. So I believe this hard, fast, it should be 1 year or nothing deadline for a 60B is inappropriate. It is incorrect. It is reasonable time. And as far as the continuance and the docket, it does note on the docket itself, March 28th order continuance. It is April 30th hearing is continued to May 16th. And then says hearing set, docket notion, magistrate's order, service has not been perfected. Wife is to perfect service for trial on May 16th. Then motions will be heard and addressed. Notice of hearing issued, notice of failure of service, instructions for service, summons to appear, notice of hearing, certified mail return receipt requested. Again, certified, not ordinary US as it's supposed to go. And then finally, certified mail complete. And it was upon getting a copy of that that we see that it was complete upon the notice of show cause. And I know opposing counsel was harping that the court has no duty to inform Mr. Ward of his trial date. They said, no, we just had to serve a copy of the show cause. We have no duty to tell him about the trial date. The duty is in due process. It's reasonable time. It's reasonable notice. And when you see that many failures of service, that's all that's on the docket between the date the continuance is granted and the date that the hearing is actually, this show cause is served upon my client is just failure of service, certified mail again, against the Ohio rules of civil.
And counsel, you need to, you're out of time.
And that's time. Thank you so much.
Thank you. Thank you both for your presentations to the court this morning. The matter will be taken under advisement, and we will issue a opinion that will be sent to both of you. And also you can look on the Supreme Court website. But thank you very much for your arguments, and I hope you both have a great day.